The term Steagall Act usually refers to four provisions of the U.S. Banking Act of 1933 that limited commercial bank securities activities and affiliations within commercial banks and securities firms. Congressional efforts to repeal the Steagall Act referred to those four provisions. Those efforts culminated in the 1999 Gramm Leach Bliley Act, which repealed the two provisions restricting affiliations between banks and securities firms. The term Steagall Act is also often used to refer to the entire Banking Act of 1933, after its congressional sponsors, Senator Carter Glass of Virginia, and Representative Henry B. Steagall of Alabama. This article deals with only the four provisions separating commercial and investment banking. The Article 1933 Banking Act describes the entire law, including the legislative history of the Glass-Steagall provisions separating commercial and investment banking. A separate 1932 law also known as the Glass-Steagall Act is described in the article Glass-Steagall Act of 1932. Starting in the early 1960s, federal banking regulators interpreted provisions of the Glass-Steagall Act to permit commercial banks and especially commercial bank affiliates to engage in an expanding list and volume of securities activities. By the time the affiliation restrictions in the Glass-Steagall Act were repealed through the GLBA, many commentators argued Glass-Steagall was already dead. Most notably, Citibank unregistered trademark S 1998 affiliation with Salomon Smith Barney, one of the largest U.S. securities firms, was permitted under the Federal Reserve Board unregistered trademark S then existing interpretation of the Glass-Steagall Act. President Bill Clinton publicly declared the Glass-Steagall law is no longer appropriate. Many commentators have stated that the GLBA unregistered trademark S repeal of the affiliation restrictions of the Glass-Steagall Act was an important cause of the late 2000s financial crisis. Some critics of that repeal argue it permitted Wall Street investment banking firms to gamble with their depositors' money that was held in affiliated commercial banks. Others have argued that the activities linked to the financial crisis were not prohibited by the Glass-Steagall Act. Commentators, including former President Clinton in 2008 and the American Bankers Association in January 2010, have also argued that the ability of commercial banking firms to acquire securities firms helped mitigate the financial crisis. The sponsors of both the Banking Act of 1933 and the Glass-Steagall Act of 1932 were Southern Democrats, Senator Carter Glass of Virginia, and Representative Henry B. Steagall of Alabama. Legislative history of the Glass-Steagall Act. The article on the 1933 Banking Act describes the legislative history of that act, including the Glass-Steagall provisions separating commercial and investment banking. As described in that article, between 1930 and 1932 Senator Carter Glass introduced several versions of a bill to regulate or prohibit the combination of commercial and investment banking and to establish other reforms similar to the final provisions of the 1933 Banking Act. On June 16, 1933, President Roosevelt signed the bill into law. Glass originally introduced his banking reform bill in January 1932. It received extensive critiques and comments from bankers, economists, and the Federal Reserve Board. It passed the Senate in February 1932, but the House adjourned before coming to a decision. The Senate passed a version of the Glass bill that would have required commercial banks to eliminate their securities affiliates. The final Glass-Steagall provisions contained in the 1933 Banking Act reduced from 5 years to 1 year the period in which commercial banks were required to eliminate such affiliations. Although the deposit insurance provisions of the 1933 Banking Act were very controversial, and drew veto threats from President Franklin Delano Roosevelt, President Roosevelt supported the Glass-Steagall provisions separating commercial and investment banking, and Representative Steagall included those provisions in his House bill that differed from Senator Glass' unregistered trademark S Senate bill primarily in its deposit insurance provisions. Steagall insisted on protecting small banks while Glass felt that small banks was the weakness to U.S. banking. As described in the 1933 Banking Act article, many accounts of the Act identify the Pecora investigation as important in leading to the Act, particularly its Glaser-Steagall provisions, becoming law. While supporters of the Glaser-Steagall separation of commercial and investment banking cite the Pecora investigation as supporting that separation, Glaser-Steagall critics have argued that the evidence from the Pecora investigation did not support the separation of commercial and investment banking. This source states that Senator Glass proposed many versions of his bill to Congress known as the Glass Bills in the 2 years prior to the Steagall Act being passed. It also includes how the deposit insurance provisions of the bill were very controversial at the time, which almost led to the rejection of the bill once again. The previous Glass bills before the final revision all had similar goals and brought up the same objectives, which were to separate commercial from investment banking, bring more banking activities under Federal Reserve supervision and to allow branch banking. In May 1933 Steagall a unregistered trademark S edition of allowing state-chartered banks to receive federal deposit insurance and shortening the time in which banks needed to eliminate securities affiliates to 1 year was known as the driving force of what helped the Glass-Steagall Act to be signed into law. The Glaser-Steagall provisions separating commercial and investment banking. The Glaser-Steagall separation of commercial and investment banking was in 4 sections of the 1933 Banking Act. The Banking Act of 1935 clarified the 1933 legislation and resolved inconsistencies in it. Together, they prevented commercial Federal Reserve member banks from dealing in non-governmental securities for customers, investing in non-investment grade securities for themselves, underwriting or distributing non-governmental securities, affiliating with companies involved in such activities. Conversely, Glass-Steagall prevented securities firms and investment banks from taking deposits. The law gave banks 1 year after the law was passed on June 16, 1933 to decide whether they would be a commercial bank or an investment bank. Only 10% of a commercial bank's income could stem from securities. One exception to this rule was that commercial banks could underwrite government-issued bonds. There were several loopholes that regulators and financial firms were able to exploit during the lifetime of Glass-Steagall restrictions. Aside from the Section 21 prohibition on securities firms taking deposits, neither savings and loans nor state-chartered banks that did not belong to the Federal Reserve System were restricted by Glass-Steagall. Glass-Steagall also did not prevent securities firms from owning such institutions. S&Ls and securities firms took advantage of these loopholes starting in the 1960s to create products and affiliated companies that chipped away at commercial banks' deposit and lending businesses. While permitting affiliations between securities firms and companies other than Federal Reserve member banks, Glass-Steagall distinguished between what a Federal Reserve member bank could do directly and what an affiliate could do. Whereas a Federal Reserve member bank could not buy, sell, underwrite, or deal in any security except as specifically permitted by Section 16, such a bank could affiliate with a company so long as that company was not a OE engaged principally in such activities. Starting in 1987, the Federal Reserve Board interpreted this to mean a member bank could affiliate with a securities firm so long as that firm was not a OE engaged principally in securities activities prohibited for a bank by Section 16. By the time the GLBA repealed the Glass-Steagall affiliation restrictions, the Federal Reserve Board had interpreted this and those restrictions to mean a banking company could acquire one of the world unregistered trademark S largest securities firms, as described in the article Glaser-Steagall, decline. By defining commercial banks as banks that take in deposits and make loans and investment banks as banks that underwrite and deal with securities, the Glass-Steagall Act explained the separation of banks by stating that commercial banks could not deal with securities and investment banks could not own commercial banks or have close connections with them. With the exception of commercial banks being allowed to underwrite government-issued bonds, commercial banks could only have 10% of their income come from securities. The Glass-Steagall legislation page specifies that only Federal Reserve member banks were affected by the provisions which, according to secondary sources, the Act OE applied direct prohibitions to the activities of certain commercial banks. Glass-Steagall decline and effective repeal. It was not until during 1933 that the separation of commercial bank and investment bank was considered controversial. There was a belief that the separation would lead to a healthier financial system. Later on, over the years, the separation became controversial. By 1935, Senator Glass himself attempted to repeal the prohibition on direct bank underwriting by permitting a limited amount of bank underwriting of corporate debt. In the 1960s, the Office of the Comptroller of the Currency issued aggressive interpretations of Glass-Steagall to permit national banks to engage in certain securities activities. Although most of these interpretations were overturned by court decisions, by the late 1970s bank regulators began issuing Glass-Steagall interpretations that were upheld by courts and that permitted banks and their affiliates to engage in an increasing variety and amount of securities activities. Starting in the 1960s, banks and non-banks developed financial products that blurred the distinction between banking and securities products, as they increasingly competed with each other. Separately, starting in the 1980s, Congress debated bills to repeal Glass-Steagall unregistered trademark affiliation provisions. In 1999, the Gramm Leach Bliley Act repealed those provisions. These and other developments are described in detail in the main article, Glass-Steagall, Decline, under the following topic headings: Glass-Steagall developments from 1935 to 1991, Senator Glass unregistered trademark repeal effort, Comptroller Saxon unregistered trademark Glass-Steagall interpretations, 1966 to 1980 developments, increasing competitive pressures for commercial banks, limited congressional and regulatory developments. Reagan administration developments, state non-member bank and non-bank bank loopholes legislative response, international competitiveness debate, 1987 status of Glass-Steagall debate. Section 20 Affiliates, Greenspan-led Federal Reserve Board, 1991 Congressional action and firewalls are €1,980 and 1990s bank product developments, securitization, CDOs, and OS or Premier credit, ABCP conduits and SIVs, OTC derivatives, including credit default swaps. Glass-Steagall development from 1995 to Gramm Leach Bliley Act of 1999. Leach and Rubin support for Glass-Steagall repeal Need to address a market reality status of arguments from 1980s, failed 1995 Leach bill. Expansion of Section 20 affiliate activities. Merger of Travelers and Citicorp, 1997-98 legislative developments, Commercial Affiliations and Community Reinvestment Act, 1999 the Gramm Leach Bliley Act, also known as the Financial Services Modernization Act of 1999, repealed part of the Glass-Steagall Act of 1933. The GS Act had prohibited any one financial institution from acting as any combination of an investment security firm, a commercial bank and an insurance brokerage. Therefore, the GLBA Act removed the barriers which the GS Act had established upon the financial institutions in the 1930s for acting as any combination of an investment/security firm, a commercial bank and an insurance brokerage. Thus, with the passage of the GLBA Act, any one financial institution after combining any of the following: 1. An investment/security firm, 2. A commercial bank and 3. An insurance brokerage could act as the combination of those financial entities. That is to say, these three separate, financial entities no longer had to be separate with the passage of the GLBA Act. The legislation was signed into law by President Bill Clinton. Aftermath of repeal. Because the Federal Reserve unregistered trademark interpretations of Glass-Steagall sections 20 and 32 had weakened those restrictions, commentators did not find much significance in the repeal of those sections. Instead, the 5-year anniversary of their repeal was marked by numerous sources explaining that the GLBA had not significantly changed the market structure of the banking and securities industries. More significant changes had occurred during the 1990s when commercial banking firms had gained a significant role in securities markets through a Euro-OE Section 20 affiliates a Euro after the financial crisis of 2007 a Euro-08. However, many commentators argued that the repeal of Sections 20 and 32 had played an important role in leading to the crisis. Other commentators argued that the repeal had helped end, or mitigate, the crisis. The main article on this subject, Glasser Steagall, Aftermath of Repeal, has sections on commentator response to Section 20 and 32 repeal, financial industry developments after repeal of Sections 20 and 32, Glasser Steagall a Euro or repeal a Euro and the financial crisis. It also mentions that in the 1960s the Office of the Comptroller of the Currency made the Glass-Steagall Act allow national banks to engage in a variety amount of Securities Act activities. In the essay by Naley, from the Federal Reserve History website, she also mentions the important information presented above but expanded with it more. For example, she expands on what banks can underwrite, which includes commercial paper, mortgage-backed securities, equity and corporate debt, as long as these contribute to a small percentage of their affiliate Euro unregistered trademark's revenue. She also adds that the Office of the Comptroller of the Currency allows banks to engage in mutual fund-related activities including discount brokerage services. Glass-Steagall in post-financial crisis reform debate. Following the financial crisis of 2007-08, legislators unsuccessfully tried to reinstate Glasser Steagall Sections 20 and 32 as part of the Dodd-Euro-Frank Wall Street Reform and Consumer Protection Act. Currently, bills are pending in United States Congress that would revise banking law regulation based on Glasser Steagall-inspired principles. Both in the United States and elsewhere, banking reforms have been proposed that also refer to Glasser Steagall principles. These proposals raise issues that were addressed during the long Glasser Steagall debate in the United States, including issues of a Euro fending Euro commercial banking operations and a Euro narrow banking Euro proposals that would sharply reduce the permitted activities of commercial banks. Please see the main article, Glasser Steagall in Post-Financial Crisis Reform Debate, for information about the following topics. Failed 2009-10 efforts to restore Glasser Steagall Sections 20 and 32 as part of Dodd-Euro-Frank, post-2010 efforts to enact Glasser Steagall-inspired financial reform legislation, Volcker rule ban on proprietary trading as Glasser Steagall Light, further financial reform proposals that refer to Glasser Steagall, UK and EU Euro fending Euro proposals, similar issues debated in connection with Glasser Steagall and a Euro OFI rules a Euro. Limited purpose banking and narrow banking, wholesale financial institutions in Glasser Steagall reform debate. Glasser Steagall references in reform proposal debate. See also, Glasser Steagall, Decline, American International Group, Arthur Vandenberg, Commodity Futures Modernization Act of 2000, Corporate Law, Global Financial Crisis of 2008, Subprime Mortgage Crisis, Systemic Risk, Notes. References. Further reading, Anderson, Benjamin, Economics in the Public Welfare, New York, D. Van Nostrand Compagnia. Bath, James R. Brumbaugh, Ardan, J. R. and Wilcox, James A., Policy Watch, The Repeal of Glasser Steagall and the Advent of Broad Banking, Journal of Economic Perspectives 14, 191 a 204, doi, 10.1257/JEP 14.2.191, JSTORA 2647102a. Blass, Asher A. Grossman, Richard S., Who Needs Glasser Steagall? Evidence from Israeli Euro Unregistered Trademark S Bank Share Crisis in the Great Depression, Contemporary Economic Policy 16, 185 a 196, doi, 10.1111 per Joule 1465-7287.1998 TB00511X, retrieved February 27, 2012 A. Burns, Arthur F., The Ongoing Revolution in American Banking, Washington, D.C. American Enterprise Institute, ISBN A0-8447-3654-6A. Culminated, Charles W. White, Eugene N., The Origins of Federal Deposit Insurance, Chapter 5 in the Regulated Economy, A Historical Approach to Political Economy, edited by Claudia Golden and Gary D. Libercap, Chicago, University of Chicago Press, ISBN 0-226-30110-9, Journal of Comparative Business and Capital Market Law 5, 137 193, retrieved February 27, 2012 A. Culminated, Charles W., U.S. Bank Deregulation in Historical Perspective, New York, Cambridge University Press, ISBN A0-521-58362-4. Canals, Geordie, Universal Banking, International Comparisons and Theoretical Perspectives, Oxford. New York, Clarendon Press, ISBN A0-19-877506-7A. Coggins, Bruce, Does Financial Deregulation Work? A Critique of Free Market Approaches, New Directions in Modern Economics, Northampton, Massachusetts, Edward Elgar Publishing Limited, ISBN A1-85898-638-9A. Faisaley, M. Nicholas, Bank Regulation and Financial Orthodoxy, The Lessons from the Glasser-Steagall Act, Review Analyse Financier Re, 49 €52A. Hambly, Winthrop P., The Great Debate What Will Become of Financial Modernization, Community Investments 11, 1 €3, retrieved February 16, 2012 A. Whitters, Thomas, Chapter 1, The Regulation of Financial Institutions, A Historical Perspective on Current Issues, in Benston, George J., Financial Services, The Changing Institutions and Government Policy, Englewood Cliffs, New Jersey. Prentice Hall, ISBN A0-13-316513-2A. Crosser, Randall S. and Rajan, Raghuram G., Is the Glasser-Steagall Act Justified? A Study of the U.S. Experience with Universal Banking Before 1933, American Economic Review 84, 810 €832, JSTORA 2118032A. Lewis, Toby, New Glasser-Steagall Will Shake Private Equity, Financial Newser. Master, Loretta J., Repealing Glasser-Steagall, The Past Points the Way to the Future, Federal Reserve Bank of Philadelphia Business Review, retrieved February 25, 2012 A. Minsky, Hyman, Can It Happen Again? Armonk, New York. M. E. Sharp, ISBN A0-873-32213-4A. Meshkin, Frederick S., How Big a Problem is Too Big to Fail? A review of Gary Stern and Ron Feldman. Unregistered trademark S. Too Big to Fail, The Hazards of Bank Bailouts, Journal of Economic Literature 44, 988-1004, doi, 10.1257/gel44.4.988, retrieved February 25, 2012 A. Pekara, Ferdinand, Wall Street Under Oath, The Story of Our Modern Money Changers, reprints of Economics Classics, New York, A. M. Kelly, LCCNA 68-20529A. Saunders, Anthony. Walter, Inco, Universal Banking in the United States, What Could We Gain? What Could We Lose? New York, Oxford University Press, ISBN A0-19-508069-6A. Saunders, Anthony. Walter, Inco, eds., Universal Banking, Financial System Design Reconsidered, Chicago, Irwin Professional Publishing, ISBN A0-7863-0466-9A. Uchittle, Louis, Elders of Wall St. Favor More Regulation, New York Temesa. White, Eugene Nelson, Before the Glaser-Steagall Act, An Analysis of the Investment Banking Activities of National Banks, Explorations in Economic History 23, 33 doi, 10.1016/0014-4983, 86, 90018-5A. Willis, Henry Parker. Chapman, John, The Banking Situation, American Post-War Problems and Developments, New York, Columbia University Press, OCLCA 742920A. Wilmarth, J.R., Arthur E., Walmart and the Separation of Banking and Commerce, Connecticut Law Review 39, 1539 1622, SSRNA 984103A. External links, Glaser-Steagall Act or further readings, on the systematic dismemberment of the Act from PBS's Frontline, full text of the Glaser-Steagall Act followed by New York Federal Reserve Bank explanation, Glass Subcommittee hearings, Pecora investigation hearings, FDIC history, 1933-1983, 1987 Federal Reserve Bank of Kansas City Jackson Hole Symposium on Restructuring the Financial System, Public Law 73-66, 73D Congress, H.R. 5661, an act to provide for the safer and more effective use of the assets of banks, to regulate interbank control, to prevent the undue diversion of funds into speculative operations. 1. The Southeast Missourian, March 10, 1933 details legislative debate when passing the bill.